Welcome back to the deep dive. This is where we pull apart the source documents, find those foundational ideas, and deliver knowledge that we hope really sticks with you.
And today, we're on a mission that I think perfectly shows how these deep historical roots still shape, the very structure of our modern world.
Exactly. We're focusing on law, specifically one of those bedrock principles of justice that you see in courtrooms all over the globe.
Mm-hmm.
I mean, if you've ever watched a legal drama or even just argued with a friend, you've probably heard the phrase, the burden of proof is on the person making the claim.
Right. It feels universal. It feels like it's just common
It
sense.
does. It has this kind of universal authority. And we usually credit it to, what, common law, maybe Roman law. We sort of assume it just evolved slowly over centuries.
A gradual development.
But what if I told you that this rule, the simplest, most universal, and you could argue the most effective rule of evidence, was established over 1,400 years ago, in a single definitive judicial moment in 7th century Arabia?
And that one ruling provided the procedural DNA for legal systems across totally different cultures and traditions.
That's the real question we're tackling today. When two people have a serious disagreement, and neither one has that smoking gun, that undeniable piece of physical proof, how does a justice system figure out who's telling the truth?
And maybe even more importantly, how do you protect the person being accused from claims that are just, frivolous or even malicious?
Our source material for this is very focused, which is great. It's drawn from a legal analysis called Proof and Oath in Islamic legal precedents, and we're looking at a section on the case of the false claim.
And the author is Mr. Zahir Ahmad Mir, who's a constitutional and corporate lawyer. He's really known for his ability to connect this ancient jurisprudence to modern legal practice.
So our mission is precise. We're going to pull out what's basically the golden rule of evidence that was established by the Prophet Muhammad, peace be upon him, and then trace its massive impact.
And I think we have to stress, this isn't just a quaint historical anecdote we're discussing. This is the fundamental architecture of what's called procedural law.
Okay, what do you mean by that exactly? Procedural law.
It's the set of rules that dictates the entire flow of a legal case. Who speaks first? Who has to present evidence? What happens if they can't? It's the heart of any fair judicial process.
So this isn't about the substance of the law, like whether theft is illegal, but how you prove theft in a courtroom.
Precisely. And the weight of this specific precedent it's monumental. The ruling from this one case became the conceptual bedrock for that entire sequence of events in courtrooms everywhere. It sets the default state, the legal inertia that a claimant has to overcome.
All right, so before we get into the nuts and bolts of the ruling itself, let's set the scene. Context is everything. We're talking about the early days of Medina.
Absolutely. You have to picture it. This is a pivotal moment. A brand new, diverse community is forming. It's growing rapidly. And with that comes the absolute necessity of creating clear, impartial, and effective legal structures.
To resolve the inevitable conflicts that come up when people live together.
Right. And think about what that means. They don't have centuries of case law to fall back on. No giant established legal codexes like the Romans. They are defining the very basis of how justice is going to work in real time.
So every decision they make could become a foundational principle.
Every single one. The decisions weren't just about settling the argument in front of them. They were about creating these enduring principles that would have weight for millennia. This environment demanded rules that were simple, logical, and universally applicable. And that's exactly what this case gave them.
So the stage is set for a perfect test case. And it's often the simplest disputes, isn't it, that require the most profound legal ideas to solve them fairly.
That's so true.
Our source says 2 men appear before the Prophet Muhammad, and their dispute was something incredibly common, but also deeply intense, who owned a particular piece of land.
A classic conflict.
And crucially, this wasn't an easy case. It wasn't like one guy showed up with a notarized deed. The problem was they both claimed ownership, but neither one had that clear, irrefutable proof.
And that lack of paper evidence is exactly what makes it the perfect scenario for defining a universal rule.
Why is that?
Well, because if every case had perfect documentation, you wouldn't need sophisticated legal principles, you'd just need a clerk to check the papers. The whole point of a justice system is to provide a fair process for when things are ambiguous.
That makes sense. The law has to function in the gray areas.
It has to. Now, look at the approach of the claimant. That's the person starting the action, the one who wants to change the status quo.
The one saying, this land should be mine.
Exactly. The source notes that this man argued loudly. He was passionate, insistent, demanding that he be given the land immediately.
It's a dynamic you still see today, right? In courtrooms, in public debates.
Oh, absolutely. The person who tries to substitute volume and emotional intensity for actual hard evidence. The hope is that the sheer force of their personality will persuade the judge.
So the judge in this case, the prophet, had to cut through all of that noise. His initial inquiry was all about impartial evaluation. The source says he listened carefully. He observed their demeanor, their testimony.
But just listening isn't enough, is it? Procedural law needs structure. It needs a clear way to assign the burden of proof. You can't just go on a gut feeling.
So after the claimant makes his loud, passionate case, the judge needs facts.
He needs facts, and this is where we get the single question that structures the entire legal process that follows.
The prophet poses a very stark, very procedural question to the claimant. He asks, do you have any witnesses?
And that's the moment. That one question shifts it from just being a story or an argument into a formal legal procedure. The law, at that point, demands something specific. It demands bayina.
Bayina, that's the Arabic term for compelling evidence.
It is, and we need to spend some time on that word because it's so important. By asking for it, the judge establishes the first rule of the game. If you make the claim, you have the burden to produce the bayina that supports it.
And the claimant's failure to meet that burden is what sets this whole golden rule in motion. His answer is simple.
No, O messenger of Allah.
That's it. Case closed for him, procedurally speaking.
For that line of argument, yes. By admitting he has no witnesses, no evidence, no bayina, he basically loses his ability to keep the claim going based on his word alone.
So the law is protecting the defendant. It's stopping him from having to defend himself against a claim that has, well, literally no evidence behind it.
It's a procedural backstop. The burden that the claimant took on when he filed the complaint just collapses.
Now, this is where it gets really interesting because the process pivots. The prophet doesn't just dismiss the case out of hand. The obligation shifts. It turns to the defendant, the one who is denying the claim.
And the ruling moves away from demanding proof from the defendant. This is key. Instead, it demands a solemn affirmation. The prophet turns to him and says, "Then you must take an oath."
And the source provides this crucial, fascinating detail here that really elevates the whole thing. The defendant, he hesitated.
He hesitated. And that hesitation is silent testimony, isn't it? It speaks volumes. Why would he hesitate if he's innocent?
Well, the source explains it. The oath, in that context, carried absolute divine accountability.
Let's really dig into this concept because this is where the genius of this system really shines and where it's so different from a lot of modern secular law.
Okay, so if you lie in a modern courtroom, you're committing perjury. You might face a fine, maybe jail time. The consequences are temporal. They're earthly.
Exactly. The whole risk-reward calculation is based on this life. Can I get away with it? Are the potential penalties here and now worth the gain?
But in this 7th century Madinah setting, the idea of sacred testimony just completely changes the game.
It transforms the oath. It's not a formality you mumble in front of a court official. It is a profound, direct contract, a promise you are making before God.
So lying isn't just a judicial offense.
Yeah.
In this framework, it's a spiritual catastrophe. It carries eternal consequences.
And that's why he hesitates. The defendant isn't just nervous about being in a courtroom. He's facing a potential existential crisis. The stakes have just become eternal.
So this deep moral and divine weight, it's like an ethical failsafe that's built right into the legal mechanism itself.
It changes the entire economics of lying. A person might be willing to risk lying to a human judge, but if the system can successfully make you believe in the deepest possible spiritual consequence, well, only the truly innocent or maybe an incredibly hardened person who doesn't believe at all would dare to take that oath.
It's a self-regulating truth mechanism.
It is. It's designed to filter out falsehoods through the defendant's own conscience.
Okay, but what if someone is that hardened liar? What if the defendant proceeds, takes the oath, and is later proven to be false? Does the law have a recourse for that?
That's a great question. The system does account for it, yes. The initial ruling, in the moment, hinges on the power of the oath as a deterrent. But in later Islamic jurisprudence, if irrefutable proof nu bayina emerges that the oath was false, the worldly penalties are extremely severe.
Why so severe?
Because it's not just perjury at that point, it's seen as a profound breach of sacred trust with both the community and with God. But for the purpose of resolving the immediate dispute, when there's no other evidence, the oath is accepted as the highest form of denial.
So you end up with this beautiful balance. The claimant is protected because their unsupported claim can't just succeed on its own.
Right.
And the defendant is protected from malicious claims, but at the same time, they're held in check by this ultimate fear of divine punishment if they try to lie to protect their position.
That tension is the crucial counterweight. The claimant has the burden of proof. The defendant has the burden of solemn, truthful denial. It ensures procedural fairness even when human evidence is completely absent.
This whole story, this single fight over a piece of land, it all leads to one of the most powerful and long-lasting legal axioms ever created.
It's what lawyers call the ratio decidendi.
The what?
Ratio decidendi. It's a Latin term. It means the reason for the decision.
Yeah.
It's the core legal principle that comes out of a judgment, the part that becomes binding for all future similar cases.
And in this case, the prophet delivered a quote that crystallized the entire procedure. A ruling so clear and efficient, it became the foundation for almost every procedural system that came after it.
He said, "The burden of proof is upon the claimant, and the oath is upon the one who denies."
It's so simple. That's the genius of it. It creates an instant, clear roadmap for how to handle any dispute. Land, money, reputation.
Yeah.
It doesn't matter. It's universal.
And to give it the authority it deserves, the source points out this isn't just a story passed down. It's recorded in the canonical hadith collections, specifically Sahih al-Bukhari and Sahih Muslim. This is settled doctrine.
All right, so let's unpack that first half of the ruling in more detail. The burden of proof is upon the claimant. This is the engine of the whole rule. The claimant must provide that bayina.
And we have to pause on bayina again because it's so central. It's often just translated as evidence, but that doesn't quite capture it.
It's a richer concept.
Much richer. In this legal sense, bayina means clear, compelling proof. Evidence that is so sufficient it establishes the truth of your claim and can overturn the legal presumption that things are fine as they are.
So things like witnesses.
Witnesses, physical objects, signed documents. But whatever it is, it has to be persuasive. It has to be undeniable.
It functions like a procedural gate.
Yeah.
A judge has to maintain the current situation, the status quo, unless the bayina is strong enough to force a change.
Exactly. If you're currently living in a house, the law presumes you have the right to be there until someone brings compelling evidence to prove otherwise. It's what modern lawyers call the presumption of continuity.
So what's the deep logic behind that? Why force the claimant to carry such a heavy burden?
The rationale is fundamental to having a stable society. The claimant is the one trying to change things. They are the one alleging a wrong has been done or a right has been violated.
They're introducing the disruption.
They are. And if the law allowed anyone, just based on their word, to force other people to prove their innocence, the whole system would grind to a halt.
Right. I mean, imagine if I could just claim with zero evidence that you owe me $10,000.
And then the law required you to prove that you don't owe it to me.
How would I even do that? I'd have to prove a negative. It would be impossible.
You'd be stuck in endless, expensive legal battles defending yourself against completely baseless harassment. So the rule is a shield against legal anarchy. It tells the claimant, if you want the court to intervene and change reality based on your word, you better bring the receipts.
Otherwise, the current reality stands. That's the procedural economy of it.
Precisely. This demand for bayina ensures that justice starts with facts, not with feelings or volume. If a claim is unsupported, the system just legally blocks it. It saves everyone's time and resources for cases that actually have some evidence to consider.
Okay, so what happens if the claimant fails to produce bayina, like in the land dispute? Is he banned from ever bringing that case up again, or is it just settled for now?
That's a really sharp legal distinction. In that moment, the failure to produce bayina settles that specific dispute. The defendant wins, the status quo is upheld.
But what if he finds a witness later?
Well, in many of the legal systems that codified this rule, if the claimant later discovered new, compelling evidence, new bayina that wasn't available before, they might be able to bring the matter back to court. But based on that initial procedural failure, the case is decisively rejected.
The failure of proof means the defendant wins the battle.
Yes. And you can see how this requirement that the person making the claim has to prove it is the direct ancestor of the presumption of innocence in criminal law.
And the presumption of rightful possession in civil law.
Exactly. Innocence is the default state until proven otherwise.
Which brings us to the other half of the rule, the defendant's move. If the claimant fails to bring the bayina, the defendant isn't just automatically free. They have one final solemn thing to do.
Correct. They clear themselves by taking that oath before Allah. It's the prescribed way to deny the claim when there's no proof from the other side. It brings legal closure.
But why is it even necessary? If the claimant already failed, why does the defendant have to do anything?
Because the claimant's failure only proves that they lack evidence. It doesn't actually prove the defendant is innocent or truthful.
Ah, I see. It's a subtle but important difference.
It is. The oath serves to formally and definitively end the dispute. The defendant uses this sacred testimony to remove any lingering cloud of suspicion and get a final judgment in their favor. It puts the ultimate moral weight behind their denial.
So there it is, the balance we keep coming back to.
Yeah.
Justice demands one of two things. Either proof from the claimant, the bayina,
Or solemn denial from the defendant, the oath.
it's like a judicial firewall against two different kinds of injustice. It stops a malicious person from winning just by being loud, because their words have to be backed by evidence.
And at the same time, it stops a guilty defendant from getting away with it just by staying quiet, because the divine weight of the oath acts as this profound truth filter.
So going back to your earlier point,
Yeah?
how much does the power of this system rely on the defendant actually believing in those eternal consequences?
I think it relies on it heavily. That's the original engine of the mechanism.
And if you translate this principle into a modern secular court, where the oath is really just a formality backed by a threat of a perjury charge, does it lose some of its power?
That is the central challenge of secularizing this system. The legal structure remains. The burden is still on the accuser. But you lose that self-regulating ethical force.
The oath loses its teeth, in a way.
It loses its ultimate deterring force, for sure. In those systems, judges have to rely much more on things like cross-examination, circumstantial evidence, trying to gauge credibility, because the oath itself isn't the same kind of moral barrier for a determined liar.
So the genius of the original ruling was using spiritual accountability to drastically shrink the margin for human judicial error.
That's a perfect way to put it. The two parts, the demand for bayina and the solemnity of the oath, they work together. It's an elegant, powerful system designed to deal with human error and malice by invoking the highest possible form of accountability.
What's so amazing is that this principle didn't just stay in one place, or only in societies that held that same view of the oath.
No, not at all. The underlying logic of this procedural law was just so sound, so effective at preventing fraud, that it naturally migrated. It influenced legal systems all over the world through trade, through scholarship, through conquest.
It's the ultimate connection point, isn't it? It shows that sound legal logic is universal, and the source document we're using draws this explicit line to the common law tradition.
The very system that's the basis for law in the UK, the US, Canada, Australia.
Right. And the common law rule is often stated with a Latin maxim, affirmanti non neganti incumbit probatio.
Which is a fancy way of saying.
He who asserts must prove. It's basically a direct translation of the spirit of the prophet's ruling. It shows this incredible parallel in legal logic across centuries and civilizations.
And we can't overstate the significance of that parallel. You're seeing the exact same procedural philosophy pop up in completely different legal cultures that grew thousands of miles apart.
What does that tell you?
It tells you how efficient the mechanism is. It's a universal solution to the universal problem of contested facts. It doesn't matter if you're settling a dispute in 7th century Medina or a complex commercial contract case in New York today. The logic is identical.
If you want a system that's fair, that minimizes successful lying, and that doesn't waste everyone's time, you have to adopt this rule.
It becomes a filter. It's a filter against fraud and inefficiency. If potential claimants know from the start that they can't meet that bayina standard, they're discouraged from even bringing the case.
It saves the courts a massive amount of time and protects people from the harassment of baseless lawsuits. It's about legal economy.
That's the term for it. But how did the idea actually travel? I mean, these legal systems weren't developed in a vacuum.
That's a good question. What were the historical channels for this idea to move from say, the Middle East into Western law?
Well, historians point to a couple of key vectors. One was the Iberian Peninsula, Spain and Portugal, during the centuries of Islamic rule there. There was a huge amount of legal scholarship and intellectual exchange, with works being translated and absorbed.
And the other?
The Mediterranean trade routes. Merchants from different lands needed common legal understandings to handle disputes. Commercial law, contract law. A lot of these foundational concepts found their way into European legal thinking through those channels, and eventually that influenced the development of the common law.
So it's not just a coincidence. It's the result of pure logic being applied to a necessary problem and then being shared and adopted across cultures.
Exactly.
And this isn't just a historical curiosity. It's not just a theoretical parallel we're talking about. Our source material points directly to its active modern use in countries with this legal heritage.
It's codified. It's written down on the law books today.
Yes, the principle of Bayina and the role of the oath is right there in sections 117 to 119 of the Qanun-i-Shahadat order in Pakistan, which is basically their Foundational Evidence Act.
And that single legal reference is concrete proof of the longevity of this 7th century ruling. I mean, when a modern, complex state like Pakistan codifies a principle that comes directly from a prophetic ruling, it shows you that the core logic is just. It's immutable.
Yeah.
It's necessary for good governance.
So let's look at those sections a bit closer. The Qanun-i-Shahadat order governs all evidence and procedure in their courts. What does Section 117 actually say?
It explicitly lays out the burden of proof. It says that whoever wants a court to give a judgment on a legal right, which depends on facts that he asserts, must prove that those facts exist.
That's the claimant's burden. The Bayina requirement, written in modern legalese.
It's a perfect match.
Okay, so 117 covers the initial claim. What about the other sections? Do they get into the defensive side of it, the denial and the oath?
They do. Section 118 deals with what's called the burden of production, basically, who has to bring forward specific evidence once a case is underway. But Section 119 is crucial because it deals with the consequences when a claimant fails to produce that evidence, and it reinforces the defendant's position.
So the entire legal machinery in these sections is designed for procedural fairness.
Exactly. It's not just for land disputes anymore. It's for all civil and criminal cases. It stops judges from making arbitrary decisions based on guesswork. It forces them to follow a rigid, evidence-based process that always favors the status quo until sufficient proof is brought to overturn it.
And a lot of the credit for this principle becoming so central goes to the major Islamic jurists who came later. The source mentions Imam Malik, Abu Hanifa, and Imam Shafi.
And their role was absolutely critical. You have to remember, the Prophet's ruling was a specific judicial precedent. It was case law.
In response to one land dispute.
Right. What these jurists did, these intellectual titans, was they systematized the law. They took that specific ruling and they elevated it. They codified it as a universal doctrine of fairness. They made sure it wasn't just about land, but about the entire spectrum of legal conflict.
So they established the scope of the rule. They made sure it applied to both civil and criminal law.
And that universality is so important. It doesn't matter if you're a plaintiff in a civil court arguing over a contract or a prosecutor in a criminal court accusing someone of a crime, the rule is the same. The party making the claim bears the burden of proof.
It's an incredible synthesis. The system sees truth as sacred testimony. It demands bayina from the claimant, and it offers the powerful mechanism of solemn denial, the oath, to the person being accused.
And that creates the structural balance in any legal fight. It ensures that innocence, or rightful ownership, is the presumed reality until the evidence is strong enough to destroy that presumption.
It really is a masterclass in legal economy. One simple rule that solves the most complex procedural problem: what to do when facts are in dispute.
If you can't prove it, the denial stands. And that denial is backed by the ultimate fear of divine consequence.
The structural elegance is that it forces responsible action. The person who wants the court to step in and change things has to be the one to act first, to bring the evidence, not just the complaint.
And that active responsibility placed on the claimant is what prevents the system from being abused. It's why this golden rule, born in the 7th century, is still the very foundation of procedural fairness all over the world.
The analysis in the source material really drives home that the success of this principle comes from a deep understanding of human nature.
Our tendency to assert rather than prove.
Exactly. And this rule creates a systematic barrier to that very human flaw. It reminds you that the first job of a judge isn't to figure out who's telling the truth. It's to figure out whose job it is to bring the evidence forward.
That's the procedural heart of it all.
So to bring this all the way back around, let's summarize the core lesson from that simple 7th century land dispute. Justice doesn't begin with emotion. It doesn't begin with volume or with mere assertion. It begins with cold, hard, compelling evidence. With Baina.
And the procedural structure they established back then is still the gold standard because it deals so effectively with the weaknesses of human testimony and conflict. It asks that one simple question: who wants the status quo to change?
And then it places the burden squarely on their shoulders.
The moral takeaway from the source is just timeless, isn't it? Every word sworn before God or even affirmed under a judicial oath in a secular court is a contract with truth. And that moral weight, whether you see it as eternal or just temporal, is what makes the whole structure work.
So let's connect this back to the listener. Why does understanding a 1,400-year-old land dispute in Medina matter to you today?
It matters because this ancient rule is the ultimate guardrail against unsupported accusations. It guarantees procedural fairness in every modern courtroom that's inherited this DNA. You cannot be condemned on mere suspicion. You can't be condemned on malice alone.
The accuser must prove their case.
They must. And if they fail, your solemn denial is enough to clear your name.
And we should one more time give credit to our source, Mr. Zahir Ahmad Mir, a constitutional and corporate lawyer, author of over 55 books. This kind of deep analysis is only possible because of that kind of rigorous scholarship.
Which brings us to a final, provocative thought, one that feels incredibly relevant right now.
We live in a world where assertions travel much, much faster than facts. We're surrounded by it on social media and the 24-hour news cycle. The speed and the volume of a claim often seem more important than the quality of the evidence behind it.
The burden of proof is just ignored. Amplification and loudness have become a substitute for bayina. So what are the consequences for society?
When we forget this foundational principle, that truth requires compelling evidence and not just an overwhelming number of retweets, what happens?
We start to erode the very structural balances that this ancient rule was designed to protect. The legal system demands bayina to change the status quo. If we start applying a weaker standard in our public discourse, we risk condemning people and ideas based on nothing more than unsupported accusations.
It's a powerful thought. We have to constantly reflect on the difference between a formal, evidence-backed claim and a casual, amplified one. And maybe we need to ask ourselves if we, as a society, are upholding that golden rule in our own lives and demanding bayina before we accept an assertion as truth.
A critical question for our time.
A powerful thought to end on. Thank you for joining us for this deep dive into the origins of justice. Reflect on the power of bayina, and we'll catch you on the next one.